All right, good afternoon. Welcome to the first seminar of the 6th season of the Nathanson Centre. As a series on legal philosophy between state and transnationalism. We're fortunate to have with us today Professor Paulo Barrozo, who's a professor of law at the Boston College Law School in Boston. It's in Boston, it's not in Cambridge, is it?
It's actually Newton,
in
Massachusetts,
Newton, Boston,
which is a suburb
College
of Boston.
Law School in Newton. Professor Barrozo's work focuses on criminal law, national and international, as well as legal theory, both applied and general. A bit about him: he received his SJD. That's the name of a PhD in law at Harvard Law School, from which he got it. And he also has another doctorate, a PhD in political science from the Rio de Janeiro University Research Institute. So in your question, you can refer to him as Professor Doctor. He's, before joining, that is, Boston College Law School, Professor Barrozo was a clerk, how do you pronounce? B-Y-S-E?
Clark Byes.
Teaching fellow and a graduate fellow in jurisprudence at Harvard Law School. And as a lecturer in social thought at Harvard University, he was a 10-time recipient of the Distinction in Teaching Award, and the first recipient of the Stanley Hoffman Prize for excellence in teaching. And I think that goes to the fact that he's just an excellent speaker, as you'll have the privilege to notice today. No, I'm just building you up a bit, Paulo. And in addition to his academic work, and that's actually interesting, Professor Barrozo is an active advocate for the rights of the neurodiverse and the unparented. And he's appeared before international bodies like the Inter-American Commission on Human Rights and the United Nations on related issues. We are very fortunate to have Professor Barrozo with us today, and he will be presenting a paper which was circulated in advance, so most of you will have had a chance to look at it, on the Great Alliance, History, Reason, and Will in Modern Law. So without further ado, I give you Professor Paulo Barrozo for a presentation of about 30 to 35 minutes, and then we'll open to the floor for Q&A. Thank you very much.
So thank you so much. Oh, thank you. That's very kind. Thank you. So thank you so much, Michael and Francois, and to the Nathanson Centre for the invitation to speak here today. It's an honor, it's a privilege, and I looked forward to this for several weeks, and I'm delighted that I'm here today. So my friends who are constrained by friendship to be kind, even they tell me that the paper is very dense, hard to read, and that there are probably a number of papers going on here. That is too much of a tour de force, and they are my friends. So I understand that is the case. And thinking about how to speak about the paper in 30 minutes, I thought of different points of entrance. One would be to introduce the thesis of the paper that I will state in a moment, by way of recounting a little bit of the legal and political theory in the West. Another way of introducing the theme of the paper, or the topic of the paper, would be to recount some of the socioeconomic, cultural, and political history of the 19th and 20th centuries. Yet another way of presenting the thesis of the paper would be to take the internal point of view of law and tell a story about how legal frameworks and legal ideas have evolved from the second half of the 19th century to our days. That would be the internal point of view of the cathedral of law. A fourth way of getting to the thesis and to the argument here would be to take a step back and do this as a thesis in the tradition of social theories of modernity. social theories of the evolution of ideas and institutions in modern times, and a social theory about continuity and rupture in modern times. So what I think I will do after I state the thesis of the paper is to say a little bit about these points of entrance to try to persuade you of the plausibility of the thesis. And then I will stop and take your questions, suggestions, criticism, and your help so that you can rescue me from the paper as much as you can. So let me start with the entry point of the history of legal and political philosophy. So very briefly, after the Greek invention of philosophy as we have inherited it, Christianity took over, became the official religion of the Roman Empire, and those with philosophical proclivities during the early and late Middle Ages had to reconcile the tradition of Greek philosophy with Christian theology. So topics such as faith, love, hope, and the dogmas of the church had to be reconciled with Plato or Aristotle or Plotinus or a combination of them. And the figures there were Augustine and Thomas Aquinas and Abelard and a few others. Now, when the paradigm of philosophy under the auspices of theology started to experience some signs of exhaustion, philosophers in the Renaissance tried to bypass the Middle Ages and go back to ancient philosophy. So you have people like Montaigne, Descartes, Machiavelli, trying to recuperate the tradition of philosophy before Christianity. I'm painting this with the largest brushes you can imagine, of course, but at that moment, so epistemologically speaking, Western philosophy bifurcated. So there was an empiricist branch and a rationalist branch. Think of Bacon here and Descartes here. The empiricist branch told us that the way to have access to the world and to truth is to train our sensory apparatuses to capture well the reality around us and pay attention to the outcomes of trial and errors over time and the accumulated wisdom of history. So the best epistemological strategy for human beings in the world was to learn from history, to learn from tradition, because in tradition, the wisdom of accumulated trials, errors, retrials is to be found. On the other hand, on the other road, on the rationalist road, you have the idea that the way to get to truth is to depart from the senses and the world that the sensory apparatus captures, because that world cannot be trusted. Our senses lie to us. Our senses tell us that the sun is going around the earth, and it's false, so you cannot trust it. So what can be trusted? Well, what can be trusted is the pure, critical, self-referential operation of reason. So epistemologically speaking, the Renaissance philosophers, as they were bypassing Christian theology to recuperate, to recover the ancient tradition, took this sort of two lines. If you fast forward 2-3 centuries, the world is witnessing the American and French revolutions. In the years before during and right after the American French Revolutions, legal and political thought polarized around two different positions as to how to understand the world and how to better manage human life, collective life on the world. Right? So, a conservative strain that I call here in the paper historicists, like David Hume, the Scottish Enlightenment, Edmund Burke, would say, well, epistemologically, and they are connected to the empiricists of the Renaissance, epistemologically, all we can know is that which experience reveals to us through our sensory apparatus. And the most reliable guide when it comes to how we organize collective life is the wisdom that tradition has rendered to us through generations. So, no major changes. If you try to engineer society top-down, you risk setting everything off place, and chaos is going to prevail. Social coordination and cultural reproduction are a very fine, fragile flower, a rare crystal. We should never take it for granted. It's been produced over millennia of trial and error, over millennia of small, piecemeal institutional and ideational evolution. On the other side, connected to the rationalists of the Renaissance, you have those, think of Rousseau here, for instance. You have those who think, well, actually, the operation of critical reason can tell us how to escape the oppression of religion, the oppression of poverty, the oppression of politics. There is enough power in reason to create an elbow room away from tradition, from religion, from nature, so that we can experience freedom. So engineering society was not only plausible to them, was the right thing to do. There is no other way. If you surrender to religion, if you surrender to tradition, if you surrender to nature, there is no way you can experience freedom in the world. Now, as a reaction, therefore, or around the time of the French and American revolutions, historicism that is connected to empiricism, the Renaissance, and rationalism that is connected to rationalism in the Renaissance, they are as polarized as they have ever been, to my mind, in the history of legal and political thought. Then something happened in the 19th century that brought them closer together. And the thesis of the paper is that it was the emergence of the transnational political masses onto the world historical stage that brought rationalism and historicism closer back together. So if you had a chance to read the paper, I have a few pages where I try to summarize what was going on in Western and Central Europe and in the Americas as well during the 19th century. And you probably know about the famous year of 1848 in Europe. Europe was aflame, revolution, war, social instability everywhere. But there was no way to send the masses back from the stage of politics. In England, there had been electoral reforms whereby the masses came onto the political stage as electors, and the restrictions for eligibility were lowered as well. But in other places, the masses just came onto the streets in a uninstitutionalized, unorganized way. And there was no way of sending them back. So the masses were the wild horse of modern politics, and they were there to stay. Now, how do you create social stability on the conditions of the masses coming onto the world stage? How do you manage the downtrodden coming to the streets and demanding all sorts of things? Now, I'm going to make the argument in using causal terms here, but it can be correlational, can be a functional explanation. I'll make it in terms of causality because I think it's more provocative. The claim is that the elites of the 19th century and the legal elites of the 19th century created a highly adaptable, attractive conception of law and politics to manage, to tame the wild horse of modern political masses. In the paper, I use Hegel, a German philosopher of the 19th century, and Savigny, a German jurist of the 19th century, as examples of the reapproximation of rationalism and historicism. Hegel, as you know, would tell us that, again, with broad brushes, we can go into details in the discussion, we will tell us that in whatever arrangements of collective life we find in place, therein inhabits a rational core that is expressed sometimes in truncated ways, in incomplete ways, but there is a rational core that is there already. And the rational core is there already because these institutions, these arrangements are human-made. And when we act in the world, we act to actualize, to bring into reality concepts that we have created in our minds, such as freedom. So if you look at the process of history and the history that humans made over time, what they are doing is to imperfectly actualize the concept of freedom. So there is a rational core already in the arrangements of the time that needs to be refined, needs to be rectified, supplemented, complemented, but it's there. So Hegel, coming from the rationalist camp, is paying dues to history as the stage in which the concept progressively over time reveals itself as human history. On the other, coming from the other side, from the historicist side, you have Savigny. Savigny is telling us that there is something about law that is like language. It's like culture. It's like customs. It's connected to the Volksgeist. It's connected to the spirit of a people. And there is nothing artificial about a national law, as there is nothing artificial about a national language, about natural language, about English, about Chinese, about Portuguese. It's just there. It evolves organically over time. No one controls the process. No one blueprinted the process of the English language. It just evolves over time. Law is just like that. So he was telling us all this codification movement that started with the Code Napoleon of 1804 and spread fastly in Europe and the Americas and maybe in other parts of the world as well at that time. His reaction to that codification movement was to say, no, this is artificialism. It's like trying to come to Toronto and say, replace English, French with Esperanto. It's going to work out. Just do it. deposit Esperanto and it's going to run. It's going to catch and it's going to be fantastic. He's saying, it doesn't happen this way. Because law is like language, like cultures, like custom. If it doesn't come from within, it doesn't catch, has no traction. So, codification is wrong. So should the jurists just go home? No. The jurists are the central agents in the revelation of the spirit of the people on its legal manifestation. So the work of the jurist is to dig, to explore, to uncover, to dive for the pearl of the national legal system of law and give it conceptual finishing, systemic stabilization, make it attractive, coherent. So the jurists stand between the people who are living in the here and now and the law that inhabits the spirit of that people. So legal science, reason, has the job of going into history and telling us what in history is authentically a manifestation of the spirit of that people and giving it a juridical, legal scientific expression and manifestation. You see that here history and historicism is paying dues to reason, the same way that Hegel's rationalism was paying its dues to history. This rapprochement of historicism and rationalism is extraordinarily attractive, powerful, highly adaptive, and is sufficiently incoherent to bring everything under its umbrella. But an essential part of the thesis here is that it's not only about this splitting of the difference, as Roberto Unger would put it, of rationalism and historicism. The central element of the thesis here is that the will of the masses came into the agreement, came into the alliance. What I'm saying is that the masses came to run the software of the merger of reason and history that people like Hegel and Savigny wove together in the 19th century. So much so that now the masses themselves would start to defend the constitutional essentials of their societies as a matter of patriotism, as a matter of national identity, as a matter of expression of the wisdom of our founding fathers and mothers, and so on and so forth. So that the masses, the wild horse of modern politics, they themselves, because they were now running this software that sees in the historical contingent a core of rationality, and see that that historical contingent is receiving the finishing of science and reason. These masses now themselves become the defenders of that arrangement. And there are just too many examples to point to. So if you were living in the United States, maybe you saw some of that debate here just a couple of years ago, when the current federal administration was trying to approve, to pass through Congress a national access to health care legislative framework. You saw how many of those who were supposed to benefit the most from that sort of public policy were resisting, because aspects of public policy were deemed to be contrary to some of the constitutional essentials of the American polity. How did that happen? How come the masses became the first advocates of a constitutional arrangement that may or may not favor whatever agenda they have over time? So the alliance was great, not because it brought together rationalism and historicism that were relatively polarized just a century ago. It was great because the masses bought into the alliance. The will of the masses were incorporated, were enveloped by the attractiveness, the authoritativeness, the adaptability of the alliance. Now, if I'm right, what is wrong about that? Because social order is indeed a fragile achievement. Just look around to failed states, to parts of the world that are undergoing a rupture of the social fabric, and you see how dear social order is and how fragile it is. One of the greatest achievements of law, from the experience of Roman law to our days, is to be able to help mediate society's transitions from the past to the future through the present. Every day, law is the broker of society's transition from past into future. It's a very serious enterprise that the law takes on its shoulders. Anyone who studies the law carefully gains an appreciation for history, gains an appreciation for the fragility of order, for the importance of precedents, of orderliness, of keeping up with expectations. That's why in every country in the world, every year, some of the brightest and most aspirational members of each generation go to law schools. They arrive as lions. 3 years later, when they leave, most are lapdogs. How did that happen? How did transformation from lions to lapdogs happen, politically speaking? Because we learn the importance of order, how difficult it is to manage societies and to keep social cohesion and cultural reproduction over time. It's a very serious business. It's not for kids. That's the enterprise of law. So, if I'm right about my thesis, what is wrong about this? It's wonderful. When everyone was expecting that modernity, as it was causing all the cultural, social, political, psychological dislocations around the world, how come that in spite of that, you have societies such as this, highly functional, despite the diversities, despite the cultural changes, despite the economic changes? So we ought to admire and to be grateful for the Great Alliance, if I'm right. That's what happened. Now, the problem, I think, with the Great Alliance is that it stunts what matters most. What matters most, from my perspective, is that we, as a species, we have inherited a domain of capabilities that we ought to expand and to deepen. To expand and to deepen them, it matters the kind of life one lives, the kind of processes one participates in daily. I think that at this point, the Great Alliance gives us a shallow, watered-down version of democracy, of this historical sensibility that understands the importance of history, in a watered-down version of the possibilities of critical, rational thinking as moral imagination. I think that at this point, the price that we are paying for social order, the price we pay for having a diluted version of reason, history, and democracy, is both unnecessary and too high. We can do better. We can cultivate a better sense of the importance of history. We can cultivate a better sense that law is not something for kids, it's for grown-ups. It's very serious. That reason as moral imagination can imagine and reimagine forms of emancipation, equality, dignity, and freedom that are not necessarily well captured by the institutional framework within which we inhabit. And that democracy can be more than electoral, media-driven, sporadic, coming onto the world of stage of politics, just to withdraw the next day to celebrate or to lament whomever won the election. So I think that at this point, it would be advisable that we invite our historical sensibility, our commitments to democracy, and our aspirations for critical reason to rethink the terms under which we have achieved the sort of social cohesion and cultural reproduction that we now enjoy, and see if there is anything better that we can do about it. If it turns out that there is nothing better that we can do about it, at least we would have gained self-clarification. And I don't think that there is a small token to be gained from intellectual enterprises. So, in closing, because I look very much forward to the discussion here, the thesis is that in the second half of the 19th century, the wild horses of mass politics was tamed by a particular worldview that was highly adaptable, attractive, and this worldview was rendered adaptive and attractive because it combined in especially intelligent and creative ways the role of history and reason in our cognition about the world that surrounds us and how we think about the organization of law and politics and the organization of society as a whole. And that as a consequence of the attractiveness and adaptability, resilience of this worldview, contemporary masses, at least in the democracies in the West that I know best, have become the best defenders of the settlement that the alliance was created to defend. And the schools of legal philosophy, of jurisprudence, that have multiplied from the beginning of the 20th century to the end of the 20th century, they all sit comfortably within the confines of the Great Alliance, within the cognitive, moral, and practical confines of the Great Alliance. And both are just testimony to the power, to the awesomeness of the Great Alliance, of the way reason and history re-emerged in the 19th century. So I guess I will stop here and so that we can have a conversation.
Great. Well, thank you very much for this very thought-provoking paper. I guess we'll open the floor to questions. Well, maybe I can start. Not that I have had much time to think about it, but I'm actually puzzled by the last statement that you just made. You said jurisprudence and the schools of legal theory with which we're perhaps most familiar today rest within the confine of the Great Alliance. And I'm just wondering what that means for them, right? In terms of whether we should perpetuate the kind of intellectual effort that we're making as students of jurisprudence, as political theorists interested in what you, at some point in the paper, referred to as reflective equilibria.
Yeah.
Are you saying, is it part of your argument that we need to move past this? Because you seem to say the Great Alliance was great. It's provided us with social order, but at the same time, it's made us complacent, right? So, is your claim that these approaches to studying law and politics also complacent, that there is no space for them? Because many students of these disciplines would simply say, well, actually, we're not trying to make big claims about history. We're just trying to think coherently about certain phenomena. We're trying to understand what law is, period. We're not trying to make big claims about what is essential for social order or not, right? Like, so positivists, as you refer to them, would say, well, or many of them would say, we're just concerned about understanding the social phenomena. In fact, we're attempting to give a descriptive account of what it is. We're not really making any value judgment about them. And reflective equilibrium is just a methodology that aims to say, well, how should we behave ourselves? Well, let's think about our intuitions, and then let's think a bit about the principles that might allow us to flesh them out, and then vice versa, understand them. So where's your claim? Are you making a strong normative claim about these kinds of theorization, or are you simply acknowledging that they're the progeny of this kind of project, just as part of the history of idea, as it were?
So this is wonderful. Let me answer by speak a little bit again about the ways I may be wrong here. I may be wrong about the thesis, about the phenomenology of modern law and legal thought. Maybe I just got history wrong. And the Great Alliance it's nothing like that. It didn't happen. It's the reason why we have social cohesion, cultural reproduction, and that the law has showed so much continuity rather than rupture throughout modernity has to do with other things. So I may be wrong about the descriptive dimension of the paper, the phenomenology, the phenomenological account of law and legal thought. But if I'm right about that, I may be wrong about the claim that we have good reasons to try to lose the grip of the Great Alliance on our imagination. But even if I'm right about having good reasons to loosen the grip of the Great Alliance of our imagination, it doesn't mean that we should take this lightly. For me, it has lost a little bit of excitement, the study of jurisprudence, just to see how much it plays within a sandbox. Because I think that I have stepped outside the sandbox, I have boxed the schools within, and I see how they play there. That's enjoyable. It's like playing Angry Birds. My friends play that. They tell me it's enjoyable. But once you understand what they're doing, it's not very enjoyable. It's just like, really? So there is a dimension of disenchantment, of loss of intellectual interest in the enterprise that you can describe from outside, right? If I'm right. But at the same time, I don't have anything better to suggest to put in place that is nearly as developed as all the traditions of jurisprudence thought that I mentioned here in the paper are. So analytical positivism, decisionist positivism, kinetic, democratic experimentalism, all the different versions of what I call reflective equilibria theories, from Finis through Rawls to Dworkin. This is real, serious philosophical thinking in law. So it's existentially speaking, I'm in an impossible position because I'm looking at this traditional, fully developed schools of legal thought that are ongoing for many generations with a level of sophistication that is extraordinary. and I'm telling them that they are playing within a sandbox. But the person who's telling them that they're playing within a sandbox is a kid. I'm a newcomer to this, right? I don't have anything to put in place that would resemble the level of sophistication, the comprehensiveness, the depth of the philosophical work of the people that I've just mentioned. Right? So existentially speaking, it's an impossible place to be in. But I can't help being there because I think I've boxed them. And the disenchantment has been sincerely experienced. So you tell me what to do. I don't know. It was an indirect answer, but it was more of a reaction.
Follow up, Michael. The only thing I would ask you is to pass the microphone around just so that we have the question on the recording. So you can actually untether the microphone from the basis. That might make it easier. Thank you.
And I would appreciate if you could say something about yourself. Why do you study, where you study?
Okay, hi Professor, my name is Michael Poon. I'm a first year LLM MRP student here at Osgoode. So part of the reason I wanted to take this course and I tend to talk obviously is I'm interested in more on the international side of how law operates. I can't confess I'm much of a philosophy or theory guy, so this may be a bit of an interesting fit here. But one thing, and it kind of I think builds on to your last comment there, Professor, is about in terms of the sandbox. What is out there? What would be better? What's the alternative? And in one sense, I think it kind of feeds into your theory because I think in a lot of ways sometimes what sometimes the mainstream others would view like the political crazies out there who protest all the times. Aren't they actually, in practice, in operational kind of modes, challenging the sandbox? Because, they're arguing that, well, we have laws here, we have courts, we have practitioners, we have theorists who may advocate for incremental changes within the framework of law, but the whole system itself is, vicious, a circle as it were, right? It's all playing within the same kind of concept about, what is property? There's private, public property, there's behavior that we should be punishing by criminal law, but our whole concept of this, throughout the development of it through, history and common law, judges kind of thinking about, what is appropriate, how do we turn the black letter law into practice. All of it there is already kind of like within one system, without challenging that idea itself and what people should be doing, instead of just like going out and vote, taking to the streets and actually saying, no, we should be doing this instead. We should be living a different way. I would think that, maybe in practice, even outside of academia, that people are already challenging it, right? In terms of what you have here as a system and, appropriate ways to deal with social conflict right there and then. I think that's already presenting a challenge to, the system as it is.
Right.
And they're presenting, what it might be. So I'm just wondering maybe on your end, perhaps the practice of protests, in various forms, that might be the alternative. And I just want to know about your take on, I guess, maybe these social movements, social protests as the alternative kind of a thesis to the grand alliance that you've theorized. So I just want to know what your take would be on that.
No, thank you for your question, Michael. And let me take the chance to thank the students who wrote reaction papers to this paper. They were very, very thoughtful and very helpful. I'm very grateful. I have read them and I will bring them home with me and I will take advantage of them further. So thank you to those who did that. So I think that we have to take social order very seriously. We should never take this for granted. It's an extraordinary civilizational achievement that has cost a lot of history and it still costs a lot. More to some than to others, but it still costs a lot. And I guess the call, to the extent that there is a call coming from me, the call is not that we should take on arms and put the Bastille down. The call is not that we should have more revolutions or The call is not we should sort of topple governments and start from scratch, or that we should experiment with a combination of violence and the rebirth of politics under another register. That's not the call. The idealist romantic thinker in me calls for confidence that there is a well of resources in rational critical thinking, in constructive legal, moral, and political philosophy, to think carefully through what we mean by values such as emancipation, equality, freedom, dignity, mercy. And that when we think carefully, critically, imaginatively about these values and what sort of life they would create collectively, that we are able, if we continue to think carefully, to understand the institutional entailments of those values well understood. And once you understand the institutional entailments of those values well understood, we can imagine processes of living together that will create increasingly more space for a role for critical, imaginative, moral reason in the making and remaking of our collective lives than we currently experience, when history has been diluted to xenophobic, conservative, reactionary jerk reaction. Rationalism is just incrementalism, cost-benefit analysis, and reformism at the margins, and democracy has become just a national-scale big brother, right? So I think we can do better. But that's the idealist, romantic thinker in me. The call here is not for more violence, it's not necessarily for more people on the streets, although I find it to be very healthy and interesting that these phenomena that I think are all connected, the Arab Spring, the Occupy New York, the Passe Livre movement in Brazil, I think these things are all connected somehow, not only by the media that makes them possible, but sort of there is something in the air. I think it's healthy and interesting, but that's not the call, to the extent there is a call coming from me. The call is for more reason, for more constructive reasoning, more critical reasoning. And the challenge to anyone who has a call of that nature to make is that, but have you failed to comprehend the traps that reason has itself created in modern times? Have you failed to read Foucault? Have you failed to read the Frankfurt School? Where have you been over the last 50 years? Don't you understand? I do, but there is no other game in town. This is it. There is no place outside language, outside culture, outside history, outside reason. That's the best we can do. We are finite beings with infinite aspirations and longings, and that's the best we can do.
I have three hands. Just as a matter of a housekeeping, just so that it's easier for me to moderate the discussion. If you have a question or a comment that's directly on point, just go like this. And if your question is, I know Justin has one, that's why I'm saying I'm gonna give you the floor now, but just so that I can then know whether we're gonna shift topic or not. So Justin, microphone. Thank you.
I was just wondering if
Are you at Osgoode Hall, Justin? Are
yes,
you a law student?
I'm a law student at Osgoode. I have a BA in double major English and philosophy
Okay.
and an MA in English. I've sort of informally focused my studies on Foucault.
Oh, okay.
There we go.
Thank you for your paper, yeah.
Thank you. I was wondering if you believe that it's possible for a conception or a legal theory outside of the Great Alliance to take off in the way that it did without the rupture on the level of the eruption of the transnational masses. Is that sort of global shift necessary for an outside to become actualized, to sort of take root? Or is a system that's working not going to change?
Yeah, this is such another wonderful question, because it goes to the point of how cultural and social change happens, what are the mechanisms of change in modern societies, and if there is more than one mechanism, which should we prefer? Maybe there are mechanisms of change that would arrive from point A to point B in a more orderly way, and then another mechanism of change that would also arrive from point A to point B, but with a lot of disruption and violence and a sense of insecurity, right? So it's a question of understanding social change or causality, and also a question of electing between different mechanisms of change or causality once we have a sense of what they might be, right? So if you have idealist, rationalist proclivities that are, as I do, you will think that ideas are a major causal player in how changes happen. And romantic, naive people like me, they give examples of this. Oh, how was Locke's work received when he published his second treatise? How was Mill's work received when he published his Subjection of Women? Right? How was Kant's work received when he published Perpetual Peace? The implausibility of the form of collective life that they were proposing was extraordinary, right? And yet, when you look around, a lot of our world resembles a lot of what they were proposing. Right? So naive people like me give superficial examples of like this to prove the point that ideas play a major causal role in social change and evolution in modern times. Charitably accept for now that I have a point, that ideas are not more causal than changes in the way labor is structured, that are not more important than geopolitical influences, they're not more important than other factors, that less important, that they are a player. So accept that for the moment. If that is true, a new legal philosophy that would escape the grip of the Great Alliance and recast a more profound understanding of the role of history in law, that would recast and reimagine a more vibrant and attractive model of democracy, of popular participation in politics, and a kind of jurisprudence that would create a, institutionally speaking, but also in the spirit that motivates the work, a larger space for rational, critical, moral constructivism. That sort of theory would only have any causal impact if it were to receive the sort of critical fortuna that works such as that of Locke's, Mill's, and Kant have received. Right? How many, if you're a Foucault scholar, how many marginal bodies of knowledge never come to the center? They arise and disappear at the margins without ever doing anything to change what has been normalized institutionally and ideologically, right? So I guess the answer, therefore, is that sort of jurisprudence would only have a chance to have a causal impact in the way the people behave in the world if it were to cascade down and to spread out throughout society. And that only happens for works that had sort of the historical critical fortuna that very few have.
I have a direct intervention on this point, and then I'm going to move on to different questions. Gareth.
My name is Gareth McSweeney. I'm a doctoral student in philosophy. So I'm sorry.
Oh, yes.
Yeah, sorry. My name is Gareth McSweeney. I'm a doctoral student in philosophy. So I'm just on that point. I'm wondering whether or not it's not the ideas that are driving this sort of mass revolution or whatever you want to call it, but it's really just the circumstances that people find themselves in economically more than legally, right? And so that's really the driver. I mean, one of the reasons we can say that we actually see the influences of Mill or Kant or whomever else is because once the ashes are there, they're the ones who would start the rebuilding, right? It's the intellectuals come back in to then start the rebuilding after that. But what the driver is not the intellectual idea at all. The driver really is the conditions that people find themselves in economically. And such that, I mean, the Occupy movement really only took hold, I would argue, for the masses, if you want to call it the masses, because people's 401k, their pension plans were hit. And all of a sudden you have people who lost enormous amounts of value in what they had amassed over their lives, put it into a safe, what they believed to be a safe account, and then lost it all. And that's really what the driver was. It wasn't so much the idea of we need to restructure the global order of finance, or we need to come in and restructure this or that. I mean, true, there's going to be drivers that are politically and legally based, such as the civil rights movement. But I would argue this, more so the driver is the economic basis. And the only reason we see these sort of inclinations towards ideas is because of the ashes then being rebuilt by the intellectuals coming in a legal, political, or moral perspective. So I wonder if you could speak to that, because I didn't see a lot of it in the paper in that respect.
Yeah, you're right, it is there. And You may well be right about this, Gareth. So I disagree with considerable trepidation and humility here. So if you take Marx, for instance, as he turns the table on German idealism and says that, it is actually because the way Marx's philosophical anthropology, as you know, tells us that what humanized the species was laboring, the activity of labor, our bodies engaging with nature, building things like this, and put between us and nature a humanized world where we can see ourselves reflected, and that experience of seeing ourselves reflected in what we have built with the labor of our body, works of our hands, like as Locke would put it, seeing ourselves reflecting that buffer between us and nature is what humanizes the species. So we are forever dependent on how we experience practices in the world. Therefore, changes happened when the way practice is organized in the world finds a breaking point, and then changes happen. So we go from slavery to feudalism, from feudalism to capitalism, and so on and so forth. And a major historian of ideas from Canada, Crawford McPherson, in the theory of possessive individualism that some of you may be familiar with, tries to recount the history of modern political thought as ancillary to precisely these breaking points in the way practice is organized, primarily around economic activities. Right? So you may be right, you are in very good company. However, the romantic idealist in me thinks that once the breaking point is experienced, those who experience the breaking point don't look at a blank canvas of possibilities as to how to interpret their condition and where they should go from there. One of the great inventions of North America, of the North American colonies, was in the greatest teachings of those colonies was that poverty and social hierarchy did not come with nature. They were a human invention. Poverty and social hierarchy and stations were human-made. Before we could experience that, we would believe that if you were born a slave, you would die as a slave, that's just the way things should be in nature. You were born a servant, you would die like a servant, that's the way things are. You are born an aristocrat, you're going to die an aristocrat. That's the way the nature has organized the world. Right? But the moment you experience and you articulate conceptually that we are not dependent in the way we organize human society on nature that much, then we see the breaking points, we interpret the breaking points under a different light. So I guess the point that I'm trying to make is we don't operate with a blank slate, with a blank canvas of meaning giving and aspiration designing. So we interpret our human condition through lenses, and the aspirations that we have when we find the satisfaction in the way we live, aspirations that we develop, unfold, and articulate through lenses. And these lenses, I want to, again, with trepidation and humility, suggest are lenses that are created by our legal and political moral imagination. It's our capacity to imagine better forms of life, to cast new meaning on our human condition that turns breaking points into pathways to some other place, that gives us a chance to interpret and give meaning to what we experience as breaking points in certain forms of organization of practices. So, but this debate will never be, I guess, resolved. Which comes first, the sort of the material experience of the world or the ideation experience of the world. But I think that you may be right, but there is an argument to be made that we are meaning givers, we are meaning makers, and we give meaning, make meaning through these sort of theories that try to make sense of how we live and how we should live together.
Okay, Professor Vincent Chow, if you could pass the microphone down, please.
Paulo, I'm sorry, Professor Doctor. I wanted to ask if you could elaborate a little bit about this relationship that you're suggesting between the macro geopolitical picture that you've been drawing and the micro level of academic discourse, of legal theoretical discourse, right? So as I understand it, you say, well, in the second half of the 19th century, after the revolutionary period of mid-century, you see the development of as it were, almost a form of legal nationalism or something like that as a way to tame these revolutionary impulses, right? So there you have this connection between both what's going on politically and what's going on at an academic level. And then if you move from there to the present, what I heard from what you were saying, particularly earlier in the discussion period, was what you're looking at is a certain frustration with legal philosophy, and by that you were naming the figures in the general jurisprudence area. And I'm wondering why that in particular is the area that you would be most dissatisfied with, given the background that you've set out, right? So it seems like if your concern is with legal theory boxing people in, and maybe this is a roundabout way of asking, but why is the primary point of focus today the debate about positivism, which many people might think of as being overly, is being overly specific, and rather than ideologies about constitutional law, ideologies about common law traditionalism, all that sort of stuff. Why isn't that the focus rather than contemporary analytic jurisprudence?
Mm-hmm. I think that could be the focus as well. I think that the Great Alliance thesis is right. Of course, I think it's right. And I think that you can find it everywhere. You can find it in the range of policy alternatives that are seriously considered for, say, transnational financial regulation. I think you can find it in the way different constitutional orders deal with search and seizure, as we were talking about over lunch today. So I think you can find it all there as well. I just focus on schools of jurisprudence because that's what I know a little better, and because I think that's what does justice best to the aspirations of the schools of jurisprudence as well. You may ask, but why worry about law at all? Isn't this a thesis that is broader than law? Isn't this a thesis that you know, as I started the talk mentioning, could be directed to social theorists? Right? You should be in dialogue with Habermas, Foucault, Niklas Luhmann. That's where the register where it operates, right? Or you can say that, you know, this is a debate in contemporary political philosophy, and that should be sort of cast in that mold. But in part because I think that law has a special place in modern societies. Law has assumed, and I'm not the first to propose this, right? I guess Habermas and Foucault have famously. I'm trying not to destroy the sound equipment here. I may or may not succeed. So the contemporary thinkers like Habermas and Foucault and Unger have suggested that as well. I think law plays an important role in the mechanisms of social cohesion and social reproduction. So that's focusing on law to detect the mechanisms of preservationism in modern societies that led to the successful maintenance, at least in the Northwest nations of the Atlantic, but also in other parts of the world, the success in social cohesion and cultural reproduction that we find. I think focus on law is strategically important and justified because of the role that law plays in modern societies. It took over the roles that traditional family and other social networks at pre-modern, early modern societies, the role of religion, theology, churches, and other mechanisms of social interaction and networking were dissolved by the march of modernity. I think law took over many of these mediation, transition roles that those institutions used to perform before. So sophisticated, high culture thinking about law and law are an essential element, strategically speaking, to comprehend what has happened to modern societies. So I think it's justified for that additional reason as well. Was that responsive?
Well,
I feel that.
I mean, the story about, you say law taking over, that seems like a familiar story. Right?
Yeah.
We see that in the growth of the administrative state in the last 100, 150 years or so.
Yeah.
So that's a familiar story. But so it seems to me that you've got two levels going on, right? The institutional and political level, and then the theoretical level. And as I understand what you were saying earlier, is that you see a causal relationship between the level of ideas and the level of institutional and political reality. And so the question that I wonder is, like, even if you're focusing on, you say, okay, now the institutional reality is that now we're no longer relying on informal networks of family and community and whatnot, we're relying on law.
Yeah.
Still, why the intellectual parallel there would seem, why, I mean, legal theory is a very, very broad field, right?
Yeah.
And one might think, well, the sorts of debates that Hart and Raz and Finnis and Dworkin and Brian Leiter and so forth are having is a very specific debate about a very specific issue among a small group of professional philosophers, whereas really the ideology of law that you want to be critical about is more the ideology of, oh, well, constitutional law is this tradition that we all have to bow down to, or we have to respect, our common law roots, or
Right.
these sorts of things. That's
Yeah.
the source of the conservatism, or the preservationism, as I think you put it earlier.
Right. But I do think, though, as I said before, that it trickles down, that it's a software that people actually run as they go about their daily affairs. It's a software that is run by people when cousins do a rental contract, right? When, 300-400 years ago, if you were ceding a dwelling to a close member of your family, and you ask her or him to write down and sign on the conditions, that would be unthinkable. Right? It's there in the way it's there in the way we experience family life. So we now think of family life as two spouses in this journey of reciprocal discovery and surrender until they have a child that will lay on the carpet of their living room. They will not wear shoes inside the house any longer. They will go on their knees and giggle with the child. This sort of family conception is very new in the life of the species. It's a combination of how ideas about property, tax, matrimonial policy were adopted by nation states and by the people who lived under those laws and start to sort of run those softwares, right? It has to do with the size of property, the incentives, what. So I think it trickles down. And we ultimately, it's not that, everyone on the streets is going to be running a debate between Finis and Dworkin and Walder in their minds, but the real theory of contract, the conception of property as absolute and then as social function of property. So the things that Duncan Kennedy discusses in the article that students in the course, I believe, read, are things that people on the streets will talk about. It's a shared legal intuition, culture, sensibility that trickles down, I think.
Microphone. Oh, right. Can I go next after here? I just wanted to get mine.
Yeah, you're in two.
Okay. I
Okay.
thought
You are
fine.
there. Okay.
Hi, I'm a first-year LLM. I have a question about, one, your methodology, so to speak, the sources that you refer to examine what the culture of the law is.
Mm-hmm.
And second is to challenge you on the point as to whether it's possible to kind of build beyond that sandbox.
Good.
I'm very curious as to whether your choice of sources of what the law is, of how it's been justified in history, limits the potential to see what can be possible more. Because part of what it seems like is latent within your article is this concept of tension within the culture of the law and this causing sort of oppression on certain groups over history.
Right.
But then at the same time, you refer to a certain specific amount of sources of understanding of the law. Why? And secondly, is there a way to kind of go beyond that?
Thank you. Let me ask you for a little bit of clarification here. By sources here, you mean the authors that I use? You mean the historical examples or the constitutional settlement that I mentioned? What?
Well, firstly, like for example, you refer mostly to Hegel and Sevigny.
Yes. Oh, okay.
So for example, like those two seem to be your main cases that main sources that you look at. But at the same time, you seem to have some latent hope in there that there is a better alternative available.
Yeah.
But how is it possible to get there when the method of your analysis is limited to these?
Yeah.
Does that make sense?
Yes.
Okay.
You will let me know whether I understood the question. So why Hegel and Savigny? Because I think they make the most sophisticated, most compelling, most attractive case in the second half of the 20th century for the rapprochement of historicism and rationalism. When you get to Dice in England, to Ehring in Germany, when you get to Oliver Wendell Holmes Jr. in the United States, when you get to François-Genis Léon in France, when you get to Orlando in Italy, it's already too late. They are already operating under the paradigm, and the role of law and legal thought is to oil the social mechanisms of a fastly expanding industrial society where conflicts between classes and interests emerge every day, and law is already in that managerial mode that has ceased to think about the settlement. The settlement is taken for granted. Right? So I think it's too late. So I want to go earlier. And going earlier, I think to my mind, Hegel and Savigny are the most sophisticated versions of the merger that I know of. But I'm sure there are others there, and I'm sure that I miss many. Now, every time I give this paper, and this is the third time, it's the second outside my own institution, I'm tempted to tell a lie. The lie would go like this. In studying American constitutional law, and the way the Supreme Court, and it irritates you a lot if you study American constitutional law too closely. So if you do that, do parsimoniously. In studying American constitutional law and the way the Supreme Court justified decisions, I have realized that they operate with three kinds of arguments that play in a forestaging, backstaging dynamic, light and shadow. Sometimes they're going to justify a decision by saying that it is a tradition. It is a tradition of our legal and political institutions, and that this tradition has been in place for a number of years or generations. It's deeply ingrained in the legal and political culture of the nation. Therefore, this is the right thing to do. And other times they're going to say that the conception of equality, well understood, rationally understood, is incompatible with gender and racial discrimination. Therefore, the tradition that enshrined racial discrimination in the country does not stand rational scrutiny. And we should do that which reason tells us is best to do. At other times, they defer to the popular will, to public opinion. Or most states disapprove of same-sex marriage. Most states don't think that sodomy is allowed. Most states think A, B, or C. Therefore, the current standing in public opinion of the matter that is to be decided by the court will lead us to decide this way or that way. So if we study the decision and the decisions of the Supreme Court of the United States in any area of law over time, and you see how they rationalize the decision, you see the play of the deference to will, reliance on reason, or appealing to history and tradition. Therefore, that's the lie, right? Therefore, observing that, I went after where it's coming from. Why this particular dynamic between will, history, and reason has developed. How they can comfortably, sometimes within the same decision, play the light and shadow, foregrounding, backgrounding game of will, history, reason, in a way that sounds so plausible to us. If you are, even sometimes when you're in the losing side, you think, no, okay, it makes sense, it's plausible. Nothing to disrupt the order here. Right? Where is this coming from? Then, in my historical search for the origins, I went to the 19th century and I found people like Hegel and Savigny weaving together a way of thinking about law that allows for this forestaging, backstaging of reason, history, and will. That is the lie that I'm tempted to tell every time I tell the story of how I got to this, right? But it is true that you find in those decisions a predominantly historicist, predominantly rationalist, predominantly democratic approach to law that does not let the other two go. They are brought together in the same fold. It's just foregrounding and backgrounding. Right? So I think it is there. It's everywhere in the law. I think Savigny and Hegel were the best, most sophisticated, interesting formulations of the merger. Now, how to escape this if you are in dialogue with them, right? That's the only way. There is no place outside history, language, reason. Even if you are trying to recast a whole vocabulary, if you want to break from a tradition like Heidegger or Wittgenstein or the early Wittgenstein, you are still bounded by that tradition. You still want to make sense, you want to be comprehended, you want to be intelligible. Right? So it's yet just another dimension of our finitude and limitations as beings who want more than they can achieve. Right? Did I get your question?
Yeah. It just seems like the very reasoning of it is constraining to the potential for solutions.
That's well taken.
Carolina.
So I'm Carolina. I'm a student here in the combined JD and MA program at Osgoode in York. So I think you may have answered my question in what you just mentioned, but I'll ask it nonetheless. I noticed in your paper that you mentioned that various contemporary critical approaches to the study of law, which I understand to include realists, critical race theorists, feminist critiques, that they still operate within the confines of the Great Alliance. And you just did say a little bit about this, but I was wondering if you could just say a little more about how exactly, nonetheless, they find themselves within this realm, because it seems to me that proponents of these sorts of views see themselves, precisely as rewriting a legal history that they see as exclusionary and problematic, and trying to fight against preservationist tendencies. So what is it about these kinds of approaches that are revisionist, but that nonetheless, they fail to break through and loosen the grip of the Great Alliance?
Mm-hmm. I think that is, thank you. I think there would be an unfair way to explain why I think they are still within the confines of the Great Alliance. And the unfair way would be to say that they are psychologically dependent. These are fancy theories about social experimentation transformation that people feel very comfortably articulating when they live in the security, charm, and peacefulness of Toronto, Ontario, or Cambridge, Massachusetts. But that is unfair because, we are all creatures of the space and times where we live, and that should not disqualify us from proposing daring social experimentation that others should try, not us. We are too busy with snow cleaning and making sure that we can conveniently get in and out of our driveways. That is unfair. But I wanted to say it anyway. What is, I think, more to the point is that they all seem to rely and depend on a set of institutional frameworks and practices that are the creation or were enshrined by the Great Alliance, and that their views feel more like stretching from within, like if you are inside one of those body-size socks, and then you try to stretch in different directions, but you're still confined, but you can stretch in different directions, right? So I think if you look at the agenda of aspirations, the conceptions of emancipation, equality, dignity, freedom that are being proposed, and we can get into more details in all these branches of critical realist legal studies that you have mentioned, that the agenda for transformation is either well within the confines, we just want more of what others already have, or it fails to provide a reason to go and experiment. So one of the legal thinkers that I think is the most interesting and fertile in the world is Roberto Unger. And I think the problem with Roberto Unger's theory of democratic experimentalism, or Charles Sable, is that it fails to fully articulate the moral and political reasons why one should experiment and in which direction. If you fail to provide those reasons, the experimentalism is just kinetic, it's just movement. Right? It's just, nouveau cinéma. You just get in front of the camera and you experiment, right? I think that one can only indulge in failing to fully articulate the moral reasons, political reasons, why one should experiment and in which direction. One is still just relying on the fact that we have a functioning settlement that would allow us to experiment at the margins without having to confront the reasons and the risks of experimenting at the center. You want to follow up? Yeah.
Could I ask a quick follow-up, if that's okay? But then I wonder if there's maybe a bit of a danger of circularity, because positions that would seek to differentiate themselves from the tradition of the Great Alliance, it seems like on your account they would nonetheless be within its confines because they're in dialogue with it and because they're responding to it. So, but if not, then what would, a move away from the Great Alliance look like? Because, it seems like necessarily it would have to differentiate itself from the Great Alliance in one way or another. So it would need to turn back to make that distinction.
And maybe not everyone should be doing that.
Mm-hmm.
So Francois, in his very generous introduction, he mentioned that I have an interest in the rights of the neurodiverse and the unparented. When I'm working on test cases on their behalf, I'm asking that they have more of what others already have. I operate fully within the confines of the Great Alliance and the way within the Great Alliance we came to articulate our aspirations for freedom, equality, dignity. And I don't think that we should abandon that. If anything, we need more than that. I recently realized that I'm an immigrant everywhere. I grew up in a small town in southeast Brazil, and after 7 years, I went to visit my hometown just a few months ago, and I realized that you can never go back home, even when you return. So I'm an immigrant everywhere. So when I think of myself as an immigrant everywhere, when I face American immigration, when I face Canadian immigration, I want to myself just the same as American citizens and Canadian citizens have. I wanted the same short line, I wanted the same expedite, passing through immigration. I want to vote for the mayor of the city where I live and pay taxes. I just want more of the same. So the Great Alliance is spectacular. What it has given us is no small gift. So I'm not here standing like the responsible philosophers saying, let's throw it all in the air and see what comes next in the name of aesthetic, existential searches for closure. What I'm saying is that this spectacular Great Alliance has diluted all that history can give to us as an heuristic as to how to live, has diluted all that reason can give us as an imagination tool for how to live better, and has diluted the meaning of self-governance, of autonomy for self-governing polities, and that we have to revisit the premises to see if we can improve on those. Right? But in the meantime, I and everyone else should be working for the rights of immigrants, of racial minorities, of the economically excluded, of the neurodiverse, of the unparented, of gays, lesbians, transgender, like good old traditional post-war left politics.
Stephen.
Hello, I'm Stephen Hollingworth. I did my BA in philosophy here at York, and I came to it after studying political philosophy. I don't have a degree in that, but I studied some, and I still keep up with a lot of reading, and I'm in a master's of philosophy now, and my interests are very diverse. I like phenomenological existentialism like Merleau-Ponty and Heidegger, and I love German philosophy. That's why I liked your paper. It wasn't too deep for me. I really enjoyed it. Just about anything in philosophy. I came to the study of legal philosophy quite late, but it's something that I wanted to study. And what questions I had for you here, I wrote them in, I don't know if did you read all of our...
I did.
You did? Oh, good. That's great. What problem, I was thinking about what I think is very troubling in the West now is in the last 20 years, since about the early 90s, there's a large rise in neoliberal and conservative thought. Maybe it's not so striking in the United States because a lot of the aspects of the United States are very conservative when it comes to social programs and everything, but it's very striking for Canadians because we once had, a political landscape that was very socio-liberal, which I agree with completely. I think leftist liberalism is the best way to go about things. I think the greatest thing that happened in the 20th century was the rise of the welfare state and social programs because, like, for example, I've had, without getting too personal, my family and I, and everybody we know have had health problems, and we'd have no chance in the United States, just to be blunt. I could never live in that society. And we know of a lot of people that we just think, how could they ever live in a society without social programs? So really, to me, the rise of the social, I read Duncan Kennedy's paper. I thought that it was very interesting too. And when I looked at the theory, of reflective equilibrium and everything that occurred, say, after 1968, but I'm thinking of your paper as well, I don't really see an equilibrium there. I see that there's a classical legal thought, an early 19th century laissez-faire way of the atomistic individual and everything returning to the West and eroding the great gains that were made, between the late 19th century and especially in the 1960s in terms of social welfare. And I was thinking, that the Great Alliance may be falling apart because there's no longer really a balance between the social democratic or, say, social legislation. If you want to look at the law, many politicians, say in this country on the right, want to repeal a lot of the social legislation. And some of them, are almost in charge of wanting to go back to the 19th century. Well, I find that horrific, because I wouldn't have wanted to live before the 1950s, to tell you the truth. The way life was, except for a few business owners and aristocrats, life was pretty bad. And in fact, I don't blame the masses for wanting to revolt under 19th century conditions. I'm actually quite surprised. I mean, I like social order, but I don't know how, considering how bad it was for most people, say 1848, that the Great Alliance kept the masses in check. I really don't see that, considering how bad everything was. And then I began to think of Foucault and the whole theory of normalization. And then I realized that law, I think, classical law is, I think, very conservative and too conservative. The law that I really think is the best is say positive law that is linked to positive liberty instead of negative liberty. Such as, for example, social labor legislation. In Canada, we had the Canada Health Act that was re-ratified in August 1984. That was sort of the end of our federal progressivism in this country. And it guarantees everybody access to socialized medicine out of need and not on ability to pay. And I think that is where law shines in the greatest way. And I can see that as being part of the Great Alliance as well. But what concerns me is the conservative and normalizing aspect of law and the Great Alliance, and the fact that I can see the Great Alliance really holding down much human aspiration into a workaday, regimented world. If we want to look at all the predicamentia to just the intellectual ideas, and really it does not really allow, I think, the true creativity that, say, would be possible if there was actually more rationality and less historicism. So the question that I wanted to ask you is that, do you think that the Great Alliance is responsible for the fact that since the Great Recession of 2008, there has been a real return to the status quo without a lot of resurgence of left-wing ideology and people out in the streets? The Occupy movement fizzled out very, very quickly. Do you think that is the result of the Great Alliance? And that could the Great Alliance take us to something like corporate totalitarianism, where, we almost go back to a point where there's no workers' rights, where, there's a lot of institutionalized poverty and a huge lumpen proletariat? Because the way, to me, the legal socioeconomic currents are heading in the West is towards that. Mm-hmm. I think so.
Yeah, I think thank you, Stephen. I think the Great Alliance is very, very capacious and can get a lot of things under its umbrella, but not everything. I think there is an ideological compromise in the West that goes from left-leaning social democratic programs to compassionate conservative programs. Everything that goes further to the left or further to the right starts to become implausible under the ideological settlement of the Great Alliance. So I don't think everything can come under, but there is a lot. It can go from Trudeau to George Bush, right? But there is a lot that goes in there. Now, I grew up a critical of my country of birth. When I moved to the United States, I became a critical of the United States, and I'm very much so until I find some of my progressive friends and I want to provoke them. So here is a provocation in the name of historical accuracy so that we can take ownership of the world in which we live. After the Second World War, the United States taxpayers and rednecks from Alabama Mississippi, Minnesota were stationed in Central Europe, sponsoring, subsidizing the defense of Western European nations, and a missile system and a base system subsidizing the protection of Canada during the Cold War, that allowed these countries to divert resources to welfare state that the United States, for ideological and other commitments, did not. So, progressive, hippie, marijuana smoking, left Democrats in the Netherlands were sponsored by American redneck soldiers stationed in Central Europe after the Second World War. So the world is too complicated to be easily schematized in left and right. But I'm in complete agreement with you that there has been a resurgence in conservative politics that I think fails to do justice to our best aspirations as to how to live together and how to recognize in each other the moral agency that we have, and that we ought to resist that return of a more traditional version of conservatism. But we should do that with eyes wide open and do justice to the role of history and tradition. And one of my criticisms of the Great Alliance is, and the conservatism that grows under the Great Alliance, is not that they are embracing historicism or traditionalism, it's that they are failing to do justice to the role of history as a heuristic as to how to live together. So if you want, I'm a sort of your type of left progressivist that wants to see this in the challenges with eyes as wide open as possible, and to understand the complexities of the world in which we came to live and how these things are interconnected. French post-war welfare state, and American conservative Christians, fundamentally Christians, rednecks from Alabama, stationed in a foreign country, holding the lines so that expenses could be made in rebuilding those countries in the welfare state.
Actually, to respond to that, my father, who's also a Canadian, lived through that period, he also reminds me of that. And I agree that the Americans actually have sacrificed a lot. He says we're only free in Canada because of the United States. But what I add to him is I say to him, yes, but don't you think the Americans should say, we really have paid enough, and that we really want our children, if they're born with a deformity or something, to have socialized medicine. Can't we stop like an $87 billion war in...
I couldn't agree more.
And I just think if they're being this normalized, like you mentioned, the majority of them, to say, no, I don't want that, I'd prefer to stand on my own 2 feet, even if I can't. To me, I think that's a conservative aspect of historicism that really has gone too far. I think they should agitate for them, because I think they should agitate for themselves, because they live in a ridiculously wealthy country with a very wealthy elite that doesn't want to share that. And I think they've paid too much of a price. I think a lot of people in their countries, even in Canada now, we are getting a wealthier and wealthier elite. And most people have been falling behind since 1985. And I just think that, I think there has to be, a redress. I don't mean radical revolution and killing people. That didn't work in the Soviet Union. It doesn't work in China. But I'm saying, I think if there isn't a redress, I'm really frightened that this trend all over the West will lead to radically polarized populations, and I think very little freedom for everyone except that capitalistic elite. And if you're not born into it, or if you're not a business genius or something, or somehow subsidized, there's no way, I don't think the society will certainly give what it did to the baby boomers, say, who lived under that, what I would say a reflective equilibrium, and they had so many more opportunities.
Thank you for this comment.
Okay, I'm sorry I've gone on, but I liked your paper, by the way.
Thank you. Thank you so much.
I love
Sim.
German philosophy, did justice to it.
Thank
We
you.
have time for one last question, Professor Giudice.
Okay. Thank you. I thought I was more confused than I might be about what the alliance between history, reason, and will amounted to. I'm not sure I want to call it a great alliance rather than a necessary or an inevitable alliance, given that it seems very hard to offer a sound account of law, not just modern law, but law at any time, which doesn't, in some respect, explain how history, reason, and will have come together or not.
Yeah.
So I'm not sure whether the great alliance, as you take it, is a particular kind of combination between these three, or whether it's just in general, it's sort of a genus category in which these three elements come together. And if it's not a particular combination, but a genus, and I think I do get misled in the paper when you talk about a need or a normative account of escaping or loosening the grip of the alliance. I don't think that's the right normative language to be adopting. It might be something, instead of escape, but balance, right? But not just balance. I think the first step is self-awareness. I don't think you're actually advocating that we try and escape from offering an account of law or political society, which doesn't make reference to these three elements, but rather being self-aware of that play of elements, and then using that self-awareness to try and figure out whether in some particular time or place we've got the balance right. Because I think it's just impossible to try and think of an account of law which doesn't try and make reference to these three elements. That's why I think some people are having difficulty trying to think, well, what would be beyond it? What would be outside the sandbox? Maybe we're not building the proper sand castles. Maybe that's a problem of refinement rather than abandonment or escape.
I think thank you. I think you understood the paper better than I did, likely. So the Great Alliance is an instantiation of a recurrent phenomenon in law, which is a combination of a will that posits the law, or a will that goes onto the stage as anonymous, collective will, making claims to the law, about the law, or through the law, history and reason. So in pre-modern law, or in the ancient theological Judeo-Christian theology, the will was the divine will who posited the law through revelation. Then you have the sort of rational explication and development, for instance, in the scholars of law in the Jewish tradition, of the meanings of the revealed law, so that you create a body of jurisprudence. At a certain point, that body of jurisprudence has to be rationally further developed, but also in a way that fits and justifies the tradition and the inherited history of explications, explanations, and glosses and constructions over time. So it has been the domain of law from as long as it's sufficiently developed to combine in different ways will, history, and reason. The Great Alliance is just a special instantiation of this phenomenon that is part of the life of law. And the Great Alliance did that in particular ways. And the way it did that, I claim, is immensely attractive. It's persuasive, it's elegant, it's authoritative, has rendered immense services for modern societies as we try to navigate all the changes we went through. It's breathtaking what has happened from the end of the 18th century to the iPad. It's just breathtaking. Just take international law. The most complex, sophisticated, diverse system of law in the history of humankind took off the ground the way we know it today from 1948. Look at the organizational chart of the United Nations. Look at the body of transnational law that grows everywhere. The private organizations that have become treaty-making bodies like the Hague Convention. Right? It's extraordinary. And it's just 5 years old? So the changes have been breathtaking. And yet, we have had a dose of social stability in the West that it's hard to believe you would have, in spite of all the wars and everything, if you were given an account of the changes. So the Great Alliance is an extraordinary instantiation, sophisticated of reason, will, and history in the life of law. The problem that I find in the Great Alliance, and can be exemplified, as I was talking to Manny about the decisions of the Supreme Court of the United States, can be as exemplified in law everywhere, is that history has been transformed at this late stage in the life of the Great Alliance into a reductionist conception of history and tradition. Reason has become cost-benefit analysis in law and economics. And will has become media democracy. And I think we can do better than that. We should aspire to do better than that. There are dimensions of our aspirations that are hardly satisfied, satiated in the circumstances of such a concept of will, such a concept of history, and such a concept of reason. Now, how and in which directions, I only have intuitions and inklings and some initial ideas. But I think you understood the project perfectly well, and you put it better than I would. So it's the former rather than the latter.
Thank you.
So I think I could not end a seminar like this without asking a question with a bit of more of a transnational component. So I understood your account of the Great Alliance to pertain to the West. You said that a few times, right? It's an historical phenomenon. It's historically contingent. That's how certain factors crystallize in society. But at the same time, you say it's extremely compelling, right? It's very attractive. So what I'm trying to understand is what the normative ought that attaches to that statement, right? Because I look at other countries that are not part of the West. I look at, for example, India, with which I'm familiar given that my partner is Indian and I'm often there, where you have a legal system, but really the way the state operates is not due to the legal system, it's due to customs, right? So you have these kind of, you have really two levels of normativity. And the state is there's an aspiration, they have rights, they have a Supreme Court and so forth and so on and so forth. But the fact that a billion people manage to live together is not necessarily because of this. Social order is not imminent from that necessarily. Then I think of Egypt, right, where we have an uprising against emergency rule, replace it in the name of the Great Alliance with something like democracy, and then we turn around and say, well, that doesn't quite work, and therefore back to emergency. Is the Great Alliance something to aim for? Is it something that is valuable for everybody? Or is it something that is historically contingent and we should appreciate as such and criticize as such?
I see the Great Alliance as a special type of cladding or protection or armor that happened in this instantiation of the Great Alliance, happened to armor, to enshrine, to protect a particular type of constitutional settlement that was the constitutional settlement of 19th century Europe and the United States primarily. And that settlement had some constitutional essentials, such as representative democracy, a progressive tax system, a incrementally expanding electoral basis, individual rights that include primarily negative rights, like Stephen was mentioning, but also some positive rights in some countries and in some ways. That's what was crystallized, solidified, armored, ironclad by the Great Alliance. So the Great Alliance is attractive in itself by the way it brought together history, reason, and will, but the substance of what was enshrined is very attractive as well. The idea that you have democracy, separation of powers, that the governed have rights, that trump aspiration of society or the government, this is very attractive. And this has indeed globalized as well as the Great Alliance. If you see the claims on the streets of Palestine, on the streets of Egypt, on either side of the dispute there, if you see the claims by those in the Occupy movement here, or the Passe Livre movement in Brazil, or in the other countries of the Arab Spring, the Green Revolution in Tehran, in Iran, and the manifestations in Tehran that we've all watched on TV, the claims that are made are claims within the confines of the Great Alliance, and they are all connected in some shape or form to the first generation of that which was ironclad by the Great Alliance, or further iterations of emancipatory ideals, like Karina was mentioning, the condition of women, of the disabled, the downtrodden, of the racial minorities. So this has globalized as well. I think there hardly is any place in the world now that has not been westernized in that sense, in the sense that the Great Alliance and the content of the first generation of the Great Alliance has been globalized. And I remember reading, speaking of India, Karl Marx's, and we read that together, Vincent, Karl Marx's articles in the predecessor of the New York Times. He had a column every fortnightly. He would publish an op-ed on the British imperialism in India. And he was saying, yes, they are destroying the traditional culture, fast urbanization, the demographical changes, the cultural changes are being forced by the British, are being painful, destabilizing, horrible, just not fast enough. Let's expedite, because that's the process of emancipation. You have to get rid of that. Think of China. China is a McKinsey-run country. You can't get more westernized than this. So Karl Marx was a sort of apex of Enlightenment philosophy. Right? So it underwent a Marxist revolution, an attempt to culturally wipe out tradition, and they gave a McKinsey-like expert to run the country. There hardly is any part of the world that has not been affected, for good and ill, by Western science, the Western political settlement, and the Great Alliance that I think was created in the 19th century. So I think that has always been the case, but more now than ever, we are all on the same boat. Speaking as a species, we are all on the same boat.
And on this note, I would ask you to join me in thanking Professor
Oh,
Barrozo.
thank you. No, thank you. Thank you.